All right, good evening. Welcome everybody to Finance 445 on estate planning. This is week 4, our final week, so congratulations for making it this far. Out of the two of you that are in the class, one of you is right on track, getting a great grade. The other is finding themselves a little bit behind. I'll be in contact with you. You know who you are. To get caught up the best we can and to make sure that we get accomplished what we need to this week to pass the class. So please be in touch with me if you get stuck, if you feel like you need some help in trying to organize yourself to be able to accomplish what needs to be done in order to pass the class. You still got plenty of time, so please, if you're reviewing this at some point over the next few days, I hope that you'll do what's necessary. It'll take some effort, but if you plan out your time this week and accomplish what you have to pass the class, I think you'll be very grateful that you did to get past it and not have to retake it at some point in the future. So let me know if you've got any questions or concerns at this point. Of course, this week is a different kind of week as far as the class is concerned. There's not an assignment or discussion board due. All we've got this week is a final test. Final test is worth 180 points. There are 90 multiple choice questions. It's a fairly long test relative to other tests that I'm familiar with within the finance program. And so I just strongly encourage you to reread again, chapter 15. I know this is getting kind of repetitive. And tonight we'll cover the topics that you'll need to know for that. That'll be the bulk of this evening's session, or this evening's discussion will be about the test questions, many of which are repeat questions from previous weeks, as this test is comprehensive. So it does include everything that we've covered up to this point. So we've got a few bits of material that I want to make sure that we can cover this evening, but then we'll go ahead and spend the bulk of tonight, as I mentioned, reviewing the topics that you need to know for this week's test. All right, so you should have plenty of time on the test. Since it's chapter 15 again, you should be very familiar with the material at this point. Hopefully you'll just use it as an opportunity one more time, as I mentioned earlier, to read through the chapter, take a few notes, make sure you've got the topic areas ready when you get to the test, so that you can get through the test in good time and be able to get the grade that you were hoping for. All right. So a couple things that we want to talk about tonight. The general topic tonight is wills. And as I mentioned last week and pointed this out in last week's discussion, a common misconception about wills is that they're the same thing. So when I talk to people about having a living will, many times they think I'm referring to a written document that basically directs the assets of their estate to their family or to their heirs. And a living will, as we discussed last week, is a medical directive. A living will is a medical directive to doctors or to physicians to pre-specify or pre-decide whether or not they should unhook you from life support or not. Okay, and it's it's not very common that this happens, but it's common enough, and it creates enough problems within families that it's very important to have a living will. However, when we talk about just a will, we're talking about the more classic definition of a will, which is just a document that dictates where your things or your assets, as we call them, will go, okay, after you pass. And as we mentioned before in previous weeks, some states require you to have a witnessed document. Other states allow you to have a verbal will, okay, that would be valid as long as somebody can verify it. And some states are pretty strict and really, without a witness, to a will or to a document and some kind of, ability to test the document's validity, that will would not be observed, or it wouldn't be taken into effect by a state. So one of the first things that you need to do before preparing a will, if you're going to do a will instead of a trust, is to make sure that you understand very clearly what the state requirements are for your particular state. And if in your state you need to have a witness, make sure you've got a witness. If in your state it needs to be a typed up document, then make sure you've got that. If in your state that allows, verbal wills are allowed or something like that, then just understand that that's an option. So very easy to find. Every state has their own policies, and usually they're very clearly delineated, within a state website. So, for example, utah.gov would tell me, if I did a search within the site, what rules are applicable to estate planning in the state of Utah, whether or not we have an inheritance tax, for example, what's required on medical directives, or like we talked about before, living wills. And then also what the minimum requirement is for a will to be carried out in the state of Utah. Most states, as an aside, are very generous, or liberal, as we'd call it, in their interpretation of a valid will. What I mean by that is, if there's not a fight between family members, which is always possible, but if there's not a fight between family members and someone has anything that indicates where assets should go and nobody's contesting it, then usually the state will honor, even a handwritten note, no matter how it looks, or unofficial it looks, they'll still honor it as long as there's not somebody else to come and contest it. Now, even in the case of a valid will, even in the case of a will that's been drafted by an attorney, it never precludes family members from, bringing suit. And that's where you really start to challenge the validity of a will or a trust, is when family members bring suit and question the validity of a will or what's in a will. The most common question ends up being that, the person accomplished the will when they were not mentally able. Okay, so one of the things that children will contest, or families will contest, is the capability of the individual who wrote the will when they wrote it, and basically claiming that either there was duress by some outside party that wanted to be beneficiary to different parts of their estate, or that they just weren't in a valid state of mind when they accomplished the will, and so it can't be respected. So, just as an aside, that's a fairly common suit, fairly common challenge when it comes to wills and trusts. And as you can imagine, I mean, most individuals prior to their passing are not capable, right before their passing, of being of clear mind and of sound conscious, and in a state where they can really accomplish a will clearly. Doesn't mean that a state won't validate that will. It just means that sometimes there is valid reason for children or heirs of some kind, or even other outside parties, to question the validity of a will if it was accomplished when the individual wasn't of a capable, in a capable situation to make those decisions, or competent situation. So competency is a significant test issue, especially for seniors, that sometimes write wills or prepare wills right before they pass. And on top of that, before we start to say, well, those are just greedy individuals who are trying to get money, many times that could be the motivation, but many times it's a family member questioning, the situation with, for example, a second or third or fourth or fifth marriage, or maybe a caretaker who's been willed everything in the person's estate. There's valid reason, or at least reason for pause, when someone who's been around that senior all of a sudden becomes the sole heir to that senior's estate. Not that that wasn't what the senior wanted, but it does make sense to at least question, or at least pause and make sure that there wasn't duress or undue pressure, or any kind of odd or strange circumstances that occurred that created the will, and put that will in a circumstance or situation that wouldn't have happened otherwise, under normal conditions. So just something to consider. We don't always need to question every single situation, but it does make sense to have some skepticism, because as you can imagine, when seniors get older, sometimes they are more apt or prone to elder abuse by caretakers, and even by family members who put them under duress to accomplish a will or to accomplish a trust that ends up benefiting that individual who's putting that pressure on the senior. And then also there's a situation where there's a competency problem. The courts tend to get involved, and there are court-ordered guardianships that occur for seniors before they pass sometimes because it's deemed that that senior is not competent to make financial decisions. And as crazy as that sounds sometimes, or as mean as that sounds in some circumstances, it can be the absolute best thing to protect that individual, while they're still alive, but maybe don't have the capacity anymore to make financial decisions, and are starting to do things that are odd or unlike them, like giving away lots of their estate to people who they come across that they don't even know, or answering the telephone or answering emails and sending money off to Ethiopia or Nigeria to a scam. So these kinds of things become significant risks to seniors who are in diminished capacity as they age. And so sometimes a court has to get involved to declare guardianship or court-ordered guardianship to somebody who can look after the finances of somebody who has diminished capacity. And sometimes that's, like I say, the very best thing that can happen, because there are plenty of scammers and shysters out there that are waiting to take advantage or be predators when it comes to individuals who cannot make sound decisions or are easily bullied into making poor decisions financially. And so anyway, just makes sense for family and friends and those who care for individuals who may be getting to that point where dementia or Alzheimer's or some kind of other diminishing capacity, is affecting that senior, and to help to protect them, when it comes to providing for themselves and caring for themselves first and foremost, but also preserving, if it's their intent to, for charity or for, the heirs or the family members that they intend to care for. So anyway, it becomes a tricky issue. There's a reason why there are attorneys that specialize in elder law, and that's it, because there's plenty of work to be done, both protecting and preserving, the rights of seniors that sometimes get taken advantage of, as you can imagine. Okay, so that was kind of an aside, but we did want to talk about wills today. One of the key concepts is when somebody dies intestate, or in intestacy, which is another term for it, that individual is deemed to have died without a will or trust, meaning the state at that point, as we've discussed in the past, has to then come in and create a probate situation where the state will then dictate how those assets are distributed. Now, how does this really work in a practical sense? Well, somebody passes. The person, usually it's a next of kin type of person who is trying to help satisfy the final, tax filing and medical bills and funeral costs and all those kinds of things. The person who is deemed to be the personal representative, which usually is a next of kin type person, doesn't have to be for an individual who dies without a will. That person will go to the courts, secure an attorney, a probate attorney, who will then go through the different assets, first take an accounting for all the assets that exist, try to gather all the information that's needed. And sometimes that can be a pretty intense process, as you can imagine, with people who hide money, people who have accounts all over the place. I mean, I've had clients who are trying to take care of parents or grandparents' estates that have 20 or 30 different bank accounts and just all over the place, and just crazy different accounts everywhere. And so to try to work through all that, sometimes for an attorney and a personal representative, can take a significant amount of time. Put on top of that most probate attorneys have a full load of casework that goes beyond the case that you've brought to them. So they can't, it's not as if they can spend 8 hours a day on your case. Many of them are very, very busy, and it could take weeks before they even put sufficient time into your estate to start to get things organized. The bottom line is, when there's not a will or a trust, the state then, according to predetermined laws, will then distribute the estate for that person who's deceased. And since there are no wishes or objectives listed somewhere, which is basically what a will or a trust is, At that point, the state has to become involved and make sure that assets go according to state rules and laws, which, as we've discussed earlier, usually puts preference on a spouse. So in most states, what ends up happening is 50% of the estate that's intestate or in intestacy will go to the spouse if living, and the rest, okay, the other 50% will be split among living children. If there's no spouse, then the estate will be split between living children. If there is no spouse or living children, which actually is more common than you would think, because a lot of times they're a widow or a widower, they don't have their spouse anymore, and sometimes they never had children, or sometimes their children have predeceased them. So many times you're in a situation where there are no children or spouse. In that case, that's where you have these situations where there's a next of kin circumstance where the state then goes and finds maybe a nephew, an aunt, an uncle, a sibling, somebody who's still alive that's next of kin, closest of kin, and that individual becomes sometimes the sole heir in unique situations, sometimes where they all of a sudden accomplish a windfall inheritance because of somebody who lived alone or has been alone for a long time and had no children. These next of kin individuals sometimes are the beneficiaries of significant estates because nothing was dictated. And when the estate, or when the state, I should say, has to dictate that, like I say, next of kin becomes the beneficiary. Now, you might say to yourself, well, that doesn't sound so bad. The state gets, the spouse gets 50%, the kids get 25% if they're both children and a spouse still living. And my response to that is that's right. That's why the state created the probate laws that are out there, and so that estates could be orderly disposed of, because we have property rights, right, in this country. So estates could be disposed of to family instead of just reverting back to the state, to the government. There are probably countries, if I were to guess, and I couldn't tell you which ones, but if I were to guess, I'm sure there are countries where without a will or an estate plan of some kind, like a trust, I'm sure their government in some of these centralized countries with very powerful governments, I'm sure the governments just end up assuming those assets. Where here, the government's not going to assume those assets. The government's going to try to distribute those assets, but they're distributed at a cost because the probate attorney is definitely going to be charging by the hour to accomplish anything that they do for the estate. And like I say, another cost or opportunity cost is the fact that time can take a long time. And then finally, sometimes it creates a situation where individuals contest probate because of the fact that probate is all public information. So if I want to find out about somebody who passed away and they passed away without a trust, I can find that information out and find that information via online resources because it is public and made public, okay, by law. So that's intestacy. That's when somebody passes without a will or a trust, and then it goes through probate. Now, if you have a trust, or if you have a will that dictates where things should go, then there's the possibility that government or attorneys don't have to get involved at all, because your will or your trust would dictate what happens with all of your assets, and the government and an attorney don't have to get involved unless, as we discussed earlier, somebody's contesting the validity of the will or the validity of the trust. And in that case, then we have to get attorneys involved. And sometimes we can go through a very expensive legal battle to accomplish sometimes very little. A lot of times, in fact, a lot of trusts will write within them, a lot of attorneys will put within their trust a section that will basically say, if any of the heirs to this estate contest my wishes for this estate, they will relinquish their right to any of the assets associated with the estate, and those will be divided between the other heirs immediately. So, although that kind of language sounds pretty scary, attorneys that I have talked to, and I'm not an attorney, but attorneys that I've talked to say that language that they put in trusts about contesting the trust and losing your share of the estate, really it's just to try to discourage, as much as possible people from ruining the estate by fighting over it. When they fight over it and everybody gets attorneys, they end up ruining the value of the estate and diminishing it quite significantly once attorneys get involved. So the point of a trust is to try to keep that outside of the courts. And so sometimes, as I mentioned, if you're going to contest the trust, just be aware that some trusts, and read that, if you contest it, you'll be relinquishing your right to any of the estate. And when somebody passes and you're the beneficiary to a trust, you do have the right to get a copy of that trust if you're family. And so, that's something to make sure and review before you go on and accomplish an attorney and try to battle it out with your siblings or with other beneficiaries on a trust. We talked last time how a will basically, dictates where assets go, and we can list them out. We can list out our money, and our different accounts, different places, and then our different hard assets, and actually list them, line item them out in the trust or the will. Or we could just say all my assets will be split equally, of equal value, between my 3 or 5 children, whatever, or to my child, or something like that, or all to the certain charity, or all to this individual for the care of my pet, who I want to go to that individual, and I want there to be funds available for that pet's care. So that might sound crazy to some of you, but it sound very reasonable to others. If you love your pet and you don't have children, you may want that pet to go somebody who you've predetermined to be basically the guardian of that pet. And then you also may want some of your resources to be there for the good care of that pet as well. So those are some different things that you can do. We did talk about guardianship last time, which is basically specifying who will be taking care of your children in the event of your passing. Obviously, if you're married, it would be assumed that your spouse would take care of your children, and actually there's nothing you can do within trust work to override that. So if you're legally married and you say, okay, if I pass, I want my children to go to my parents instead of my spouse, the courts will never honor that. Now, if something happens to both you and your spouse, and both biological parents are passed or deceased, then the court will definitely honor any request in writing and official that the predeceased parents have made for where their children should go as far as guardianship is concerned. Now, of course, the individuals who are declared as guardians can always relinquish that right, okay, and waive that right and say, we're not in a place where we can take those children, or we don't want to take those children. Excuse me, which sounds really sad, but I'm sure has happened in the past, or somebody didn't know they were going to be guardian, didn't feel like they have the capacity or ability or desire to raise additional children or children at all. And so I'm sure that there have been situations where people have waived their right to do that, and then it passes to the state again. If there's not a contingent guardian, it would pass back to the state and the probate courts, and then Division of Family Services to dictate where those children should go. They might have to go to foster care, but of course, all next of kin would be approached first to see if there's anybody that's related that would take on that responsibility before they would go to the state for like a foster care program. So that's guardianship, a very important piece. We just have already talked about living wills and their importance as far as medical directives. Just, if you're wondering why, we'd even be spending any time at all talking about medical directives and how unlikely that is, there are some high-profile court cases across the country that have happened in the past few years where individuals have been put on life support, and then their families have battled in court to determine whether or not to turn off the life support. It can become a very ugly thing between family members. It can be very divisive between family. It can also be very costly. Can be very, very expensive to retain life support instead of turning off machines at some point. So just, those are some different considerations to think of, but the most important thing is to create harmony and accord within your family. You don't want your parents, for example, fighting over whether or not they should, turn off the machine. If you've already dictated that, then that will be the final say on it, and they won't have the right to supersede that. Physician, family, friends, nobody has the right to supersede your wishes when it comes to, extending or turning off life support. So if you've made that decision, you take that decision out of people's hands that really should not be making that decision for you, because that puts them in a very bad situation. We've talked a little bit about POAs, or powers of attorney, but powers of attorney are very, very important. There's commonly situations which, maybe you can't think of one, but a very common situation is somebody goes to a hospital, is out for a couple days, is unable to take care of their basic necessities or financial decision making. A power of attorney can allow a spouse or somebody else, a representative, to make decisions on their behalf for their interest while they're incapacitated or unable to make those decisions. So, commonly that's a 1 or 2 day stint in a hospital. Could be longer, could be shorter. But it could also be a situation where you get stuck out of country, or you are just out of country, by design on vacation, and you need somebody in the States maybe to accomplish something for you. Pay a utility bill. There's all kinds of different things that could happen, make a decision for you. If they've got power of attorney, they can do that. If they don't, they can't. Just as a quick example, which may sound kind of extreme, but when a spouse passes, if a utility, like let's say it's Rocky Mountain Power here in Utah, if a utility has that account under the deceased person's name, so let's say George passes away and Susan, his wife, is left behind as a widow, but the utility was under George's name. If she goes to call the utility to switch it to her name, or to shut it off, or to do something different, they won't even talk to her until she can provide them with a death certificate and with some kind of proof that she has legal authority to act on his behalf at that point. Now, if she had power of attorney, she would have been able to act even before a death certificate, but she might be waiting to get all that information and all that legal documentation, if she doesn't have a power of attorney, before she can talk to 401k providers, life insurance providers, utilities. All these different companies are very careful about privacy, as you can imagine, these days, and will not talk to anyone who is unauthorized, even if they tell them that somebody's died. That would be a way to deceive, an insurance companies, to say, hey, yeah, this person died, so I've got to act on their behalf. Well, until they have proof that that person passed and that you have legal authority to act on their behalf, they're not going to talk to you, shouldn't talk to you, okay? And that's for our protection. But it does speak to why having a power of attorney would be helpful, okay, and would be important. Putting things in joint ownership is one way to avoid some of those problems, but sometimes you can't put everything in joint ownership, and so a power of attorney can really help. Also helps, once again, in the case of diminishing capacity that we talked about earlier. So if you have a spouse that's has Alzheimer's, or has dementia, or is just suffering from a little bit of a diminished capacity, having a power of attorney to act on their behalf and make decisions for them can be very, very helpful. And in fact, just really important to have, if you feel like that's a risk. Even if you don't feel like it's a risk, powers of attorney by people that you trust or can be very helpful. So you've got two different types of powers of attorney. You've got basic springing powers of attorney, which is the most common type of POA. That type of POA only comes into effect, only becomes valid if the individual becomes incapacitated or dies, okay? So if they become disabled or die or diminished, as far as their capability, that's when a springing power of attorney or durable power of attorney comes into effect. Now, then there's also a general power of attorney. General power of attorney basically gives rights to someone, and it can be a limited power of attorney where it limits to certain types of activities, different financial decisions, or, something, you can specify within a power of attorney what types of rights that power of attorney allows and what it doesn't. So a limited power of attorney would specify certain rights and certain things that somebody can do on your behalf. And then a general power of attorney would just be, they have the ability to act on your behalf for anything that takes place. So, before you go out and hand somebody general power of attorney on your behalf, just make sure that that individual would never do anything that wasn't in your best interest, because you're giving them a lot of power. They can then take, accounts that you have, investments, savings, they could withdraw money. I mean, they can do a lot of things that give them a lot of power, and so you've got to make sure that you trust that individual with the general power to be able to do those things. Most times people don't accomplish general power of attorneys except between spouses sometimes. The most popular thing to do is have that springing power of attorney that only comes into effect when there's some need that pops up. Okay, so that's powers of attorney. It's considered part of estate planning, and a lot of times when somebody accomplishes a will through an attorney, that attorney is also going to accomplish guardianship, the living will, and the power of attorneys as needed. Okay, and then finally a quote from the book. This is from the chapter. It says, "He who acts as his own attorney has a fool for a client." The people who wrote the textbook are not estate planning attorneys who get paid to do legal work for individuals. So it's not in their best interest to put some things in a book about how you should use attorneys. They don't represent the Utah Bar Association or something like that, or Attorneys Across America or something like that. There's not some kind of message like that they're trying to advertise, or objective that they're trying to push. Most times when I talk to individuals about estate planning, they will be happy to use an attorney to make sure that they consider all the different issues and considerations that are important to estate planning. They want somebody who's very professional and experienced to help them accomplish something that's this important. Not the type of thing that you'll want to accomplish and then worry about whether or not it's going to be valid when you pass away, or worry that your children or other heirs are going to contest and actually ruin your estate through those contests and through those lawsuits because you weren't willing to pay a little bit to an attorney to do it right. It's not foolproof, but something that's important, it's worth considering or seriously considering whether or not it makes sense to employ an attorney to make that happen. Now, I'm in Utah, and as a financial advisor, I commonly get asked, well, can't I just do it through LegalZoom or online somewhere? And my response to that is, yes, of course, you can take care of it that way, if you want to make sure that it's done right, and if you want to make sure that you go through a process of discovery that's informative and insightful and helpful, very helpful, then I would strongly encourage you to consider using an attorney. Now, I don't get paid from the attorney to help, to tell you to go find an attorney. So I don't have any dog in the hunt. I don't have any conflict of interest there. But I've just seen how much value a good attorney or a good CPA or a good financial advisor, good professionals can add in the realm of finance, in the realm of estate planning, in the realm of tax. And so I encourage people to find somebody that they trust, has good experience and expertise, that can really help them when it comes to something like this. And the book, in this case, agrees. Does it mean that if you are, not able to afford it, that you should just not do your estate planning? No. The next best thing, if you can't afford estate planning or feel like you can't afford estate planning, is to just write out some of this information, find a template, do something online, get anything that you can find and accomplish as much as you can do within, the situation that you're in. Okay. So I mentioned earlier that the final has 90 questions. It's worth 180 points. You've got 3 hours to take the test, and it's from just the one chapter, chapter 15. Many of these questions are going to be repeat questions, so I'm not at all worried that any of you should take more than 3 hours to take the test. The only time that in classes that I teach, people get in a situation where they can't accomplish the test within the specified time is when they don't study at all. So if you go and take the test without having heard this session, without taking any notes, without having taken any of the previous tests or studied at all for any of them, or having read chapter 15, then sometimes it does take a long time because you're scrambling to try to come up with the answer, or you're second guessing yourself. It just takes a lot longer when you haven't prepared. If you're adequately prepared, this test should only take you an hour to hour and a half at the most. And like I say, many of the questions are repeat questions, so those should be really easy and fast. And then on top of that, like I say, we've been in the same chapter this entire mod. So at this point, if you've done what I've told you to, you've read through the chapter a couple times already. And if you read through it one more time and you have the topic areas that we've talked about tonight during the session, you should be in great shape. All right, I'm going to stop the sharing for a second, the screen share, and do what I've done in past weeks, which is go to the test and go through the information that will be on the test. So number one on the test is a question that asks you to understand the main objectives of estate planning. So we've talked about that in previous weeks. I think this is a repeat question on the test, but you'll need to understand what the book has to say, okay, what the book has to say about what the main objectives for the test are. So, and if you've got those, you'll get number one right on the test. Number two on the test says, just is a repeat question as well from chapter 1 or week 1, all from chapter 15, right? But from week 1, that asks about what estate planning is most closely linked to. So there are different disciplines that I've alluded to tonight, like tax, insurance, retirement, investment planning, those types of things. And those can all be related to estate planning. But what I want you to do is make sure you can find in the book what the book has to say, what the chapter has to say, are the closest disciplines, okay, these different disciplines, the closest disciplines to estate planning. So you get number 2 right on the test. Number 3 right on the test is about the objectives or goals of estate planning again. Just keep in mind that there are probably multiple goals or objectives that could be had from estate planning, and you'll be in good shape. Number 4 on the test is there's a misprint on the question. It should say estate planning is designed to, and once again, this is about objectives of estate planning. Instead, it says estate planning us designed to. If I can remember to, I'll edit that, but pretty easy misprint. Estate planning is designed to, and you just need to be able to identify some of the objectives, once again, of estate planning that you'd get from chapter 15. Number 5 and number 6 are about first level and second level death related costs. These are repeat questions from previous weeks, and you'll just need to find in the chapter where it talks about first level and second level death related costs, and make sure that you can identify basic categories of which is which. So if it comes up with a particular cost, you need to identify whether or not that's a first or second level cost. Number 7 on the test is a repeat that we've seen a couple times now on tests. Basically, you need to understand from the book, from the text in chapter 15, how often the book suggests that you review your estate plan. And I'll give you a hint, it's not every year and it's not never, okay? Somewhere in between once every year and never, which is a wide range, right? But that'll help you a little bit on the test question. But you'll need to know what the book has to say about how often, okay, how many years is suggested between reviews on your estate plan. You need to make sure you understand what a probate estate is. What is a probate estate? You need to make sure you understand what the book suggests are life events that would dictate an updated estate plan, and maybe some of the issues that would not justify an updated estate plan. Number 10 on the test talks about estate planning problems. Just make sure you can identify some estate planning problems. And of course, that would be at the beginning of chapter 15, where it's talking about why we do estate planning. And then when we get to the process of estate planning, what are some of the things that can go wrong? What are some of the pitfalls or problems that can happen? What are some of those, and what can we do about them? Make sure you understand the difference between people planning and asset planning. What is people planning? What is asset planning? Make sure you understand, again, what some of the main problems are with estate planning. Make sure you understand what custodial accounts are. Those are UTMA accounts, and we talked about them a little bit last week as we reviewed for the test, so that's a repeat question if I'm not mistaken. So just make sure you understand those are trusts like UTMA and UGMA accounts, which are custodial accounts. And what are they? Why are they important? Number 14 on the test, once again, is a question about second level death-related costs. So you'll want to understand what those are. You want to make sure you understand this repeat question again about estate breakup. What does that mean? What does it mean to have an estate breakup? Make sure you understand the pros and cons of using life insurance within estate planning, what the book has to say about the advantages of using life insurance as a tool within estate planning. Make sure you understand what constitutes a probate estate. There's a couple questions on probate estates. You'll want to make sure you understand basically what probate estates are and what is in a probate estate. Make sure you understand that estate rules, not the estate tax. The estate tax is a federal estate tax, right? But as far as estate issues are concerned and probate, those are different from state to state. So if you have accounts and ownership of property in different states, that can complicate your estate, right? Because then you're dealing with different jurisdictions with estate planning. Okay, so you can add complexity to an estate by having property in different states that have different jurisdictions, different rules when it comes to estate planning. Make sure you understand the basic reasons, objectives of using a trust. We've talked a little bit about that. We've also talked in 2022 is alluding to, once again, life insurance. So we want to know the reasons, the pros and cons of using trusts and using life insurance. Make sure you understand where estate taxes are levied. So we've talked about how to calculate estate taxes last week. That was your assignment. It was an assignment, basically an exercise about calculating the estate tax. How are estate taxes calculated? When are estate taxes assessed? That'll help you on number 23. Number 24 talks about ILITs, which is an acronym for Irrevocable Life Insurance Trust, So an ILIT is an Irrevocable Life Insurance Trust. How can ILITs be used and what are their advantages and disadvantages? Make sure you understand what a will is, okay, kind of along the lines of tonight. What does a will do? Okay. Number 27 on the test is asking about the valid sections of a last will and testament, which is basically a will. So what are the valid sections? What are the required sections of a valid will? So the book will give you, here are the sections that have to be present for a will to be valid, okay? So what does it mean when you die without a will? We talked about that tonight. It was one of our terms that we talked about. We talked about how probate will treat your estate, how it will be divided out. So that'll get you number 30 right on the test if you remember how that works. If not, go back to the book and study out on test to see again and how a court will usually dictate based on predetermined rules how your estate will be divided if you don't have a will. Make sure you understand how guardianship works. Okay, what is guardianship? How does it work? Another question, number 32, about a valid will. What's required for a valid will? Okay, maybe not necessarily the parts or components of a valid will like was on the previous question, but this one's more general. What is required for a will to be valid? For example, having somebody that has capacity, right? So if they're incapable of making decisions, you can't have a valid will if they created it when they were incapable of doing that. Guardianship, again, want to make sure you understand advantages, disadvantages of who you choose as a guardian. Want to make sure you understand the difference between the grantor, testator, personal representative, executor, attorneys, trustees. All these terms are different ones that the test is going to test you over a couple different times. So you'll want to make sure you understand the difference between those individuals or entities in some cases, because you can't have a bank, for example, act as executor or trustee for an estate. So it could be an entity or it could be an individual for those different roles within your trust. Number 36, again, is another question about valid wills. Okay, number 37 is another question about valid wills. What's required for valid wills? Make sure you understand how someone can revoke a will. How can you revoke a will? Make sure you understand what the book has to say about that. Make sure you understand what might be included in a letter of instruction, a letter of last instructions. So what might be included in that? That's for 39 and 40. Once again, another question about the different roles associated with trusts, executors, personal representatives, trustees, successor trustees. Just make sure you understand what those different individuals do. Make sure you understand the difference between gross estate, adjusted gross estate, taxable estate, those different terms like we talked about last week when calculating out the estate tax due on an estate. Number 43, you're going to want to understand the difference between the probate estate when it comes to calculating your gross estate. Okay, so what is included in a gross estate, what is not included in a gross estate. Okay, that's for 44 as well. Number 45 talks about what does the book have to say about updating an estate plan. Can you have an estate plan and then just never update it? Or a good estate plan, will a good estate plan require updating or not? So if you have a really good estate plan, can you just set it and not worry about it, or do you have to update it? Okay, see what the book has to say about that. That'll get you one right on the test. Make sure you understand whether or not the adoption of a child, okay, would, how that would affect an estate. So go back to the chapter and see where the adoption of a child affects an estate. See what the book has to say about that. Dying intestate, what does that mean? Let's see, a good estate plan. What is required for a good estate plan according to the book? Make sure you understand, I think this is a repeat question from a previous week because I remember seeing it. Make sure you understand whether or not a will is required by state law. Okay, are you required to have a will or not? We talked about that in the past. Not whether or not a will is a good thing to have, but does the state require you to have a will? Like it requires you to have car insurance. Okay, is there a law that says you have to have a will? Another intestacy question, just make sure you understand from tonight, what does intestacy mean? Or dying intestate, what does that mean? It's the same thing. What does it mean before you get to the test? Make sure you understand whether or not a valid will can be contested. And we talked a little bit about this tonight. A good will prevent, some people from contesting it, but it absolutely will not guarantee that people won't contest it. There are many valid reasons for children, in many cases heirs to an estate to contest a will. And no matter how good the will is, no matter how valid it is, no matter how well prepared it was, there may be good reason for somebody to contest it. Let's see here. Talks about one of the questions on the test just basically says, look, if a state has to decide where your estate is going, then like we talked about, it's really going to benefit the spouse. But it could be more or less than what you had intended. So if you intended for all your assets to go to your spouse, well, in the case of most states, only 50% is going to go to them. But you could have also intended for your money to go to your kids only, or to charity. And many times this is the case with second spouses, third spouses, second marriages, third marriages. They want their money to go to their kids, and then their spouse can take care of themselves, is the thought for many individuals who are on a second or third marriage. If that's the case and you don't have a will or trust, you may be giving a lot more to your spouse than what you had anticipated. Keep that in mind. Hard copies of a will, just to, this is kind of a no-brainer, pretty logical. If you have a copy of the will, you might want to have a copy of the will in more than one location, in electronic form, backed up in electronic form, maybe with an attorney or in a safety deposit box. Just make sure that you've got a backup to one document, of course, because things can happen, as you know. Make sure you understand what the book has to say about mental capacity. So one of the things that's required for a valid will, as we've talked about, is mental capacity. So is there a certain age? Make sure you know what the book has to say about mental capacity. Proof of mental capacity. Proof of mental capacity, just make sure you understand what the book has to say about who has the burden of proof, okay? Who has the burden of proof? So does the person who's writing the will have the burden of proof to show that they have mental capacity, or does the person who contests the will have to show that there was not mental capacity? And see what the book has to say on that before you get to the test. Make sure you understand about witnesses to a will, whether or not they can or cannot be family members. Can witnesses be family members for number 57 on the test? Number 58, make sure you understand what a codicil is. We talked about it last week. It's basically an amendment to a will, and whether or not the will, after you've done that amendment, can be destroyed. What does the book have to say about that? What does the book have to say about the fact that if you write a new will, what happens to the previous will? So let's say I wrote a will 10 years ago and I don't even know where it is, and then I write a new one. From a legal standpoint, what if when I die somebody finds that old will? Okay, what does that mean? The book is very clear on this, what happens with that old will based on the fact that I wrote a new one. Okay. And whether or not I put in this new will revokes all previous wills or not. Okay. Whether or not I put that verbiage in or not, something happens to that previous will the moment that I sign a new or more current will. Okay. Same is true for trusts. Same is associated with the rule when it comes to writing a new one. Number 59 and number 60 are repeat questions. So congratulations, you got two of the same question. You get one right, you'll get the other right. That has to do with writing a new will and what happens to the previous one automatically. Make sure you understand what the unified rate schedule is for federal taxes, for federal estate taxes. What is the unified rate schedule? It's kind of has more to do with what we talked about last week. Just do a quick review on how we do tax calculations and what that's called. Make sure you understand where the gift tax levels are. We talked about how there's gifting levels. The book, of course, has lower levels because it's a little bit older, a little bit more out-of-date material. But current levels are $14,000 per person, and you could gift split, which we talked about when your spouse is legally married, and you might be able to give up to $28,000 to an individual if you're married. So when you get to the test, if there's one that's more than that amount, then there potentially could be some gift taxes due, or at least a gift filing that's required anyway. Make sure you understand how the gift tax exclusion works. That $14,000 we were just barely talking about per person. How does it work? Is it per person per year? Is it per couple per year? Is it per every 6 months, or is it per, whatever year, year from the last time you gifted? Just make sure you understand the basics of gift tax exclusion policy. 64 is a gift tax calculation question, gross estate versus adjusted gross estate. Make sure you understand what kinds of items get pulled out of the gross estate to calculate your adjusted gross estate. Number 65 has to do with the rules associated with spouses and the unlimited marital deduction, which is basically an unlimited amount that you can gift over to your spouse or deed over to your spouse or die and then give to your spouse after death without any taxes at all. Okay, so it's the most favorable gift situation or inheritance situation that can occur within current estate laws, and that is that your estate transfers to your spouse because there is never any tax due on that transfer. Want to make sure we understand gift tax rules. Gift tax exclusion for number 66 gives you a sample problem. Number 67. Number 67 just speaks to how universal trust services are. So when it comes to the book encourages everyone to consider a will or a trust, right? And so the test is going to try to trick you and basically say, hey, which kind of people need a trust, or which kind of people need a will? And if you remember what the book has to say about both those things, you'll know that this is kind of a trick question, because the book basically thinks that there's not really anybody who couldn't use a will or a trust. Okay, that basically everybody should have some basic estate planning. We talked in week 1 specifically why that is, but just keep that in mind for the test. Number 68 is a little bit outdated. It's the total cap annual exclusion amount, and basically, yeah, I'm going to give you the answer, number 68. Number 68 is the answer is $5 million. And the reason I'm going to give you the answer is because it's outdated information, as I mentioned earlier. We've talked about the fact how the total lifetime and in-death exclusion now is a unified table, right? And the total amount is $5.43 million per person. None of the answers on number 68 are going to match what the current information and the current situation that we're in. Number 69 talks about when a gift is complete. So we talked about completed gifts and uncompleted gifts. So, for example, if I give my daughter $10, I just hand her $10 cash. That's a completed gift, right? She can go do whatever she wants with it. But if I put her on my account and I've got $1,000 sitting in my bank account and I just put her name on it, That doesn't mean that I've completed that gift yet. If she goes, though, to the bank and pulls out some money, which she very well can do because she's an owner on the account, that's when the gift would be considered completed. Why? Because I'm retaining, as a joint owner, incidents of ownership. You recall that we talked about anything that you retain incidents of ownership in is not a completed gift. Anything that you relinquish all incidents of ownership, that is a completed gift. So if I'm owner of a life insurance policy and I've put the beneficiary as my wife, that's not a completed gift, because tomorrow I could go and change the beneficiary on my policy that I'm the owner on to someone else, right? Or if I go into a charity and I say, hey, I'd like to give all my IRA to you when I pass away, and so I change the beneficiary on my IRA to the charity. Once again, not a completed gift, because a year later I could change the beneficiary to someone else or something else. So as long as I retain those incidents of ownership where I can change who will benefit from whatever asset that we're talking about, that means that it's not a completed gift, not considered a gift. So just putting a child on a checking account or a savings account does not constitute a gift. It will constitute a gift, though, the moment that they take money out of that account and exercise their right to make a withdrawal. Okay? Keep that in mind for number 69 on the test. Number 70 on the test just talks about ownership, and we talked a little bit about ownership, like types of ownership, like tenants in common and joint ownership with rights of survivorship. One of the test questions is a great tool for estate planning. Okay, correctly titling property is a great tool for estate planning. However, the book is very clear that titling different property is not a valid replacement for estate planning, right? And that makes sense, right? We still got to do our estate planning. I'm just saying that titling, and so does the book, titling can be a great tool within estate planning. And then, of course, you've got other issues that you've got to take care of as well. You want to know what the book defines a trust as? What does the book define a trust as? Number 72, you want to know what the book has to say about choosing a trustee. Okay, what to be careful of, what to be aware of when choosing a trustee for a trust. You want to make sure you understand the difference between revocable and irrevocable trusts. And you can have living trusts, okay? You can have a revocable living trust or an irrevocable living trust. So an ILIT, an irrevocable life insurance trust, is an example of a living trust. However, are revocable, and most decedent trusts, or trusts when somebody's passed away, are irrevocable. Having said that, there are exceptions to both sides. Make sure you understand what a testamentary trust is. What is a testamentary trust? Make sure you understand who pays the gift taxes, the giver or the recipient. Who pays the estate taxes? Okay, is that the estate or the inheritor? Okay, remember we talked about how some states do have inheritance tax on the individual who inherits money. Most states do not, and as far as the federal estate tax is concerned, that's charged to the estate. Okay, those taxes are charged to the estate, not the individual recipients. Now, in the end, right, who's really being charged? Well, the recipients are, because their estate is being reduced. What they're going to get is being reduced by the taxes. However, it is the estate's responsibility to pay the tax, not the individual recipients. Okay, so that's a responsibility, a fiduciary responsibility of the trustee to make sure the taxes get paid, not a fiduciary responsibility or obligation of the individuals who are getting the estate. So why is that important? Because if you receive a check from an estate and you call the attorney who took care of it, or call the trustee and you say, okay, am I able to cash this check and just spend it because I don't have to pay the estate taxes, right? The answer is you don't have the legal obligation to pay the estate taxes, but the government might go after the estate and actually might claw back some of those, some of that estate that was distributed if estate taxes weren't satisfied by the trustee. Okay, so the trustee on an estate situation is responsible for taking care of the taxes, the executor of the estate, not the recipients of, not the beneficiaries. And then when it comes to gifts, same thing is true. If I give $100,000 to my daughter, I am the one that's responsible for a gift tax return, and I'm the one responsible for any gift taxes associated with that. She isn't responsible for any of that. Okay, it's not her issue. She doesn't pay any taxes on a gift at all. Number 76, we want to go back to the idea of a completed gift versus an incomplete gift. Completed gift is one where you relinquish all incidents of ownership or control. Keep that in mind for number 76. Number 77, I want to make sure you understand powers of attorney. We've talked about that a little bit tonight, but just make sure you understand what the book has to say about a power of attorney. Make sure you understand what a durable power of attorney versus general power of attorney. We talked about that a little bit tonight. So what's a durable power of attorney? Make sure you understand what an executor does. What is their role within an estate? What's an executor do? Excuse me. Number 80 on the test has to do with gift splitting. Just make sure you understand about gift splitting, the basic rules of gift splitting. Number 81 talks about lifetime giving versus after death giving, and basically the idea is, why do we do lifetime giving? This goes back to our discussion board that we had last week or the week before, where we talked about how giving during lifetime giving, can reduce your estate taxes, because if you just keep all your estate together and then you die, there's the potential for estate taxes to be there. But if you give during your life under that 14 or 28,000, depending on whether or not you're single or married, you can reduce your estate to a point where you might not pay any taxes at all. So it's an effective strategy. Gifting or lifetime giving is an effective strategy to reduce a tax liability for estate taxes. Number 82, just make sure you understand the difference between gross estate, adjusted gross estate, and taxable estate. Okay, which one comes first, which one comes next? If you can basically run through the calculation or order of the calculation, you'll get number 82 right on the test. Number 83, make sure you understand what the book has to say about this state death tax credit. Okay, if there's a state death tax credit, make sure you understand what the book has to say about that. Make sure you understand the difference between the inheritance tax and the estate tax. We've talked about that. They are very different. Keep that in mind for the test. Number 85 on the test is just an estate tax calculation problem. Remember the threshold of $5.43 million, even for the test, and you'll be fine. Anything under that would not be a taxable estate. Number 86 on the test. What does the book have to say about the 2001 tax laws for estate planning? Number 86 on the test is true. Once again, we're talking about outdated legislation, so I don't want to hold you to that. You just need to know the current stuff as far as I'm concerned. 2001 tax laws don't apply anymore in large part, so number 86 on the test is true. Number 87 on the test, you'll want to know about citizen versus non-citizen spouses. How does that affect estate taxes? Citizen versus non-citizen spouses. Once again, number 88 on the test is about gift splitting. What are the requirements of gift splitting? Just keep in mind that you have to be married. You have to be legally married to accomplish gift splitting. Number 89 on the test, trust. What are the objectives of trust services? What can they accomplish? If you think broadly, you'll get number 89 on the test right. Don't think narrowly about what trust services can accomplish. Trust services are very broad and can accomplish a lot of things. Keep that in mind for number 89 on the test. Number 90 on the test has to do with the gift exclusion amount. We talked about how it's $14,000 this year. Just make sure and keep that in mind for the test. Okay. Now you know what's going to be on the test. We've gone through it all. Let me wrap up. We're a few minutes over tonight. Hopefully the recording will work better this time. Last time, if you listened to the recording, it was really choppy because for some reason my recording, the recording session just didn't work very well. But anyway, have a great evening. Good luck this week with the final. Let me know if you have any questions or concerns, and please, please, please do your best this week. I just hope the best of success to you with completing out your degrees wherever you're at in the process. If I can help in any way, let me know. But let's finish strong this week. If you've got any questions or concerns, let me know right away. Have a great night.